not the way law enforcement appeared to have viewed the artwork as they photographed it and reported on it. Given the science of memory and its acquisition, retention, and retrieval, this could be what is filling in her memory gaps as opposed to actual memory. When you apply the critical factors that a court must take into consideration for eyewitness testimony regarding identification, the words bushy eyebrows should be excluded. The heart of the issue is whether or not the witness is reliable enough on the issue to let the words be spoken to the jury when it comes to the description. DM said that she could not do a composite sketch because she doesn't think she saw a face. The court should enter an order excluding the words. Thank you.
The defendant relies on the Manson-Biggers test. We just went through the 5-factor balancing test for their argument. However, that test is completely inapplicable in this case. Manson-Biggers has to do when there's a law enforcement-led identification process. The concern is that through suggestive techniques by law enforcement, it could lead to or create a misidentification. Well, that didn't happen in this case because it couldn't happen in this case. The male DM saw that night was covered head to toe. The only thing that was uncovered was a portion of his face. That does not lend itself to positively identifying any particular person. Therefore, an identification procedure was not used, and that Manson-Biggers test is inapplicable. Instead, on 4 separate occasions before Brian Kohberger was even identified or arrested, DM gave consistent descriptions of the male she saw in the residence that night at around 4 a.m. Every time she described this person as being white, male, wearing all black, a few inches taller than her, she's 5'10", wearing a mask, skinny, athletic, tone build, and not a voice that she recognized. During 3 of those interviews, she then describes the male's eyebrows, and she describes them as being bushy. Obviously, there was some focus on the eyes or the eyebrows by investigators because this is the only portion that she could see. She never wavers in her description of the person that she saw. She's very clear about what she does remember and what she doesn't remember. Defense put the state of Mr. Kohberger's eyebrows into question. In an attempt to discredit DM's testimony or description, they wrote, "Mr. Kohberger does not have bushy eyebrows, but the artwork on DM's walls and the way she draws eyes and eyebrows could be described as bushy, full, or prominent." So in response, the state attached a picture of Mr. Kohberger, and obviously that's a jury question, but it was taken only hours after the homicide, so the closest in time to when DM would have seen the smell. And we did this in order to, when we did apply the Manson-Biggers test, to show that it turned out to be accurate. Corroboration does not equal prejudice. The state doesn't intend to introduce, they're correct, we would not introduce that photograph through DM. We would attempt to introduce that photograph and plan on laying the proper foundation and relevancy at trial. There's no grounds to exclude this testimony. DM's the only living individual who saw the person responsible for these 4 homicides. Her description of the male, including any characteristics such as bushy eyebrows, is relevant to the identity of the killer. It is prejudicial, but it's not unfair. A jury should hear this evidence, and the state asks that the court rule accordingly. Thank you.
I'll be brief, but I want to circle back to where I started. To say that there's no grounds to exclude this testimony is completely inaccurate because, in fact, there is a large body of case law and a large body of science about how important this testimony is. And that's why this court must analyze the reliability going through all of the factors that I expressed. And there is not certainty with DM in what she saw. And the court now has, over a variety of motions, all of the transcripts that you can look at to understand the amount of uncertainty that she expressed.
Thank you. I'll take that issue under advisement. Text message, pardon me, 911 call.
Judge, the state seeks the pretrial ruling that the audio recording of the 911 call and a transcript of that call are an exception to the rule against hearsay. The state submits that the entire 911 call should be admitted pursuant to IRE 8032 as an excited utterance. At 11:49 a.m., BF calls her friend and to come over and check the residence. The friend and a boyfriend show up to the residence. At 11:56 a.m., BF places a call to 911. Just 7 minutes later, this 911 call was immediately after learning that HJ had something was definitely wrong within the residence, and his instruction that the girl should call 911. The statements were before the declarants knew their friends had been murdered the night before. The requirements of IRE 8032 are met, as this was obviously a startling event, and two, the statements were made under the stress and excitement that it caused, and that's clear by listening to that audio. The defendant has proposed that their version of the 911 transcript be used, and the state has no objection to that. And I do have a copy of that transcript and the defendant's transcript if the court would like it. Thank you.
Well, I may ask you some more questions because it seemed to me from the briefs that the defense focused in on three particular parts of the 911 call as not falling within the exceptions. So he didn't address those specifically, but let me see where the defense is at.
Your Honor, the best place for me to start is to probably provide you with some copies of the exhibits that we're going to want to talk about. The first set I'm going to hand you was actually filed with the text messages. It's an affidavit of Josiah Roloff, and also, let me give you the extra copy. It has DM's messages broken out in bubble form. That's not all. I gave a whole separate copy for Giovanna. I think that's what I'm supposed to do.
This, to be clear, when we're talking about 911, but you're giving me text stuff.
We are, in our response to the state's motion about the 911 call, we referenced the whole copy of text messages. We just filed them with text messages, but they're appropriate here for the court to consider. I have the additional exhibits that were attached to our response, and they are 1 and 1A. 2 copies. With those in possession of the court, I'll talk about the state's request. The 911 call is made 8 hours after whatever happened in that house happened, after the killings happened. according to the state's theory of the case anyway. The state wants to play for the jury the 911 call and give them a transcript of the 911 call as an excited utterance or a present sense impression. The context of all of what happened that night is captured in DM's text messaging. There's a separate text messaging exhibit for BF. But it's not that all of a sudden at 4 a.m. something starts to happen and then the 8 hours pass and they call their friends and are startled by finding out that their roommates have been killed overnight. There's a lot more that happens during that time, and to analyze whether they're under the influence of a new and startling event, the court should take a look at all of the text messaging, all of the use of Snapchat, all of the use of Instagram that happened. It doesn't start in the middle of the night and then just stop until noon. There is a whole lot more that's going on in that house. When you hear the 911 call and you analyze each of those statements, the only statement that could possibly be a present sense impression is that from HJ. And he really doesn't say a whole lot. The other statements that wants to capture in, one is attributed to a person with the initials EA, and that person is repeating what she's been told. She says one of the roommates is passed out. And then a bit later, under prompt from either DM or BF, she says, oh yeah, and they saw a man in their house last night. Those are not things that relate to an exciting event. She's reporting things that other people are telling. She's not somebody who observed any event in the house. If the court takes a look at Exhibit 1 that came with the 911 calls, it's a smaller transcript and it comes from the grand jury transcript. If the court will look at page 277, that's numbered in the top right corner, lines 16 through 24, EA did not see anybody in that house. She went in, went to the top of the stairs and went back out, and she saw nothing. She never went back inside that house. Any statement attributed to her cannot be an excited utterance. She's repeating what other people have told her. Similarly, if you look at the grand jury transcript, this is 1A, this relates to DM, and I'm at page 187, lines 12 through 16. DM is not responding to any of the statements she makes on the 911 call to a startling event. She says that for a brief second, she saw XK, but thought she was passed out from the night before. She also wants to talk about what she saw at 4 in the morning, and the dispatcher stops her. Looking at page 190 of that same 1A transcript, DM talks a little bit about that morning when she woke up after whatever happened in the middle of the night happened inside that house, that she reviewed the text messages between her and BF from the night before. She was busy from about 9 o'clock in the morning on her phone. She was on Instagram, she was on Snapchat, she was on Indeed, she was editing pictures sometime in the night as well. This is not somebody who was asleep and then woke up and was startled. She is actively reviewing things that happened on her phone and communicating with other people. Any statement she made on the 911 call is not the result of a present sense impression. It's not the result of an excited utterance. It is somebody who's been awake and thinking about whatever she and BF talked about the night before and communicating with a lot of other people before that 911 call is made. The court should not admit the 911 call as an excited utterance, and the court should not admit the transcript for the same reason. But if the court chooses to admit one, having both is cumulative. So it would ask the court to exclude the 911 call.
Exclude the 911 call? The state has lost their ever-loving mind. I'm so glad I'm not a judge. my patients would
Judge,
be.
I think there's a misapplication of the rule as well as the event that is causing the startling event, or the reason that they're startled. State agrees that this is somewhat of a culmination. There was definitely a startling event around 4 a.m. when DM opened her door and sees an unknown person in black in the house. She's not sure what to make of this, but that's obviously a startling event, enough so that she runs downstairs to her friend's bedroom. Yes, a period of time elapses. She wakes up the next morning. The next startling event is the fact that when she wakes up the next morning, her friends, she can't hear them. And she's texting them, and that's what her phone records show. She's texting them, giving them time to respond, and they're not responding. So at this point, she decides to call over friends to come and check on the residents, remembering what happened the night before. Now adding to that, that she's not hearing the roommates above like she normally would, and they're not responding in the morning like they normally would. Then she calls her friend to come over. Then the friend comes over, discovers Santa, and then instructs them something is wrong. And to the point that they need to call 911. That's truly the startling event here, is the confirmation that all of these things are coming together and that there's an emergency in the house that law enforcement needs to respond to, which is the context of how all of these statements are made.
What do I do, what's your response to it seems like some of this I need to take bit by bit. And so, for example, EA stating that one of our roommates or one of the roommates passed out and was drunk last night. She's not waking up. She didn't witness anything.
Well, I think that falls under her presence and suppression of what is happening at that time.
Her hearsay statement of what somebody else told her,
That's
she's
true.
not experiencing anything in that sense other than being there. And I think the case of my note here of Bemis is instructive.
Well, I would also argue that for this particular statement, we wouldn't be relying on it for that truth. So therefore, it's just not hearsay. Well, solely just for the context of the entire 911 call, but we wouldn't be asserting that what she was saying is true, that the roommates has passed out and she's not waking up. That's not the purpose, or that my friend's telling me that she saw someone in the house last night.
I mean, it's not offered for the truth. You better have a good answer about what the reason is other than the truth. And I'm not hearing one.
Only that it's part of the substance of the entire 911 call. And that part could be redacted, which still, that doesn't mean that the entire call should be redacted.
So I'm addressing them individually. I mean, there may be parts that qualify and there may be parts that don't.
I still argue that the entire call in its entirety.
Well, so here's kind of the way that shakes out. If you offer the tape, you, as an initial matter, can't put in stuff that is hearsay. It's unaccepted hearsay. If they want to put in the context, if it falls under the completion doctrine, they can. If it's the other way around, in the
Come on
defense
in.
first place, the tape and parts are hearsay are left out.
I'm
You
live
want
on
to-
YouTube.
you can.
I'm live on YouTube.
But you don't get to complete with hearsay your own offered conversation or I think it applies outside the federal context to recordings
Hi, Bridget.
and testimony.
Yes, that makes sense to me.
So when you say for the whole context, that sounds like the completion doctrine.
This
I'm not sure you
is
get to
a
rely upon-
a
well, I
post
know
lunch
you
Brian
rely
Kohberger.
upon it. And so when you say it's not
Trial.
offered for the truth,
I'm live on YouTube, so
I'm not
also
hearing
join me
something
over there.
other
Join me
than the
over there.
completion doctrine.
So we can
that
watch
you're
it and
telling
talk
me
about it together, okay? YouTube,
I
YouTube,
think
go to
that's fair.
YouTube.
I mean, we only have certain exceptions to the rule.
Thank
If
you.
it, I still
Kohberger
believe that the
trial.
entire call in its entirety and under the
They're
circumstances
trying
that the
to
call was
exclude
made,
the
the
911 call.
entire call could be considered an excited utterances by all declarants.
Also, there's a statement by EA, oh, and they saw some man in their house last night. Yeah. That seems to me to even be more removed. Again, it's a statement of a hearsay of somebody else, so you got hearsay within hearsay.
Hi, Texas girl. Hi.
And not by somebody who observed that
No, this is
And look
Kohberger,
into
pretrial stuff.
previous.
That's true.
So what non-truth purposes is
Come on in,
that
come on
statement?
in.
Again, I would just have to say that the whole
Because
cause of
that seems to
excited,
me to be even more concerning,
right?
right? The first one, I mean, my roommates aren't waking up and we're going to have that confirmed through other evidence. The statement hearsay that the roommate saw somebody is perhaps more of a piece of contested evidence.
Agreed. I still,
Concern about being an offer for the truth is even greater there.
right, and the appropriate remedy, when there's not any grounds for relevancy for this, would be to solely redact those portions of the 911 call, not to exclude the entire call. And based off of the nature of the call and the fact that the phone is passed around multiple times, and it's hard to determine who's speaking at what times. And obviously a lot of emotion in their voice considering what's going on. It's not always clear to understand what's being said. So I think a transcript is a fair way also to convey this and should be allowed with the
Hey,
audio.
Hannah. I know, I was just muting it temporarily so I could explain what's going on.
Nothing further from the state.
Transcript and testimony.
Join me, YouTube, YouTube,
In
YouTube.
other
Come
words,
on. Come on over to YouTube, folks.
you're essentially
Thank you, Hannah.
admitting the evidence of somebody who transcribed it to say this is what they said. So to me, there's two different questions. One, should
Come on.
the 911
I want to build up
come in?
YouTube,
Second,
so
should I allow if there's if there is
come on over,
disagreement?
come on over. We're talking
Transcript.
about the Kohberger
Well,
trial.
the state has offered to
The
allow
state
the
is really pushing it here,
transcript that they had certified.
really pushing it. Live on YouTube. Come on over to YouTube.
The fact that certified doesn't make it otherwise independently admissible. It's hearsay. The transcript part of it.
Well, it's a transcript of the 911 call. I believe that
judicial court.
it could be self-authenticating.
Judicial court. I see you, Greta.
It has
Come on over to
sufficient standards of
YouTube.
reliability built into the transcript.
The lady in blue is for the
That may be
Defense.
one.
defense attorney,
You haven't complied
I
with the
mean,
requirements. of
not
transcript
defense,
at this point.
prosecution, excuse me.
No, but we haven't met our exhibit or witness deadline yet.
The
So
state.
obviously, we would have to lay the proper foundation for that and would intend to do so. Thank you.
I'm live on YouTube and I'm carrying the feed straight from the court. Straight from the court. So come on over to YouTube and hang out with us, okay? You can come to both. I've got it playing in the
All right, I'm
background
gonna,
here
I
and you
wanna-
can hear it.
I think
so
I need
either
to take
one.
a statement by statement approach to this. I do think that the surviving roommates,
Sorry.
surviving victims of the burglary were under the stress of the immediate events. But there are some questions about some of the other statements in there as to whether they would come in. So I think in general, much of the 911 tape meets the qualifications, but not all of it. I think there are concerns with some of them, as I've outlined in my questions.
We're trying to
But I
get the
will write that
911
because
call run out of
to
court.
give you more particular
Are you
guidance.
freaking kidding me right now? Hi, Tony. You cannot hear me on YouTube?
All right, the text messages and testimony.
Thank you, Your Honor. Similar motion by the state, asking to bring in the phone records for a DM between 2:10 a.m. and 4:37 a.m. on November 13th, as well as related testimony around that same time between DM and BF. Again, the state submits that there are allowable exceptions to the rule against hearsay to allow these statements to
Thank
come
you.
in. I broke those down in my motion and reply and the applicable rules for their introduction. This is a much easier piece of evidence in order to be able to present certain time periods and not put in non-hearsay.
She did.
It's much easier than an audio recording where we would have to redact. But for the messages that DM sends and the messages that
one did I
BF
cover?
responds, I think all of those are allowable
This one or
under
that
the
one?
excited utterance, as well as the present sense impression exceptions to the rule against hearsay.
I'm live on YouTube, TikTok.
If you have any
Mods,
questions about any
if
specific,
there's any mods in here,
messages.
just keep hitting that I'm live on YouTube. I want to build up the YouTube too. Come on over where we can watch the trial and talk about it together. 4:30
Well,
Eastern
Your Honor
time?
has
Okay.
our
I'm going to leave
exhibits
at 4:30 to
already
cover
related
the
to
Lord's
this,
Supper.
and then in the record were BF's phone activity. I don't need to quote extensively from those. There's a lot more to the text messages than the state has provided to the court, and the lot more
You too.
makes a difference when you put all of these into
Eastern Standard
context.
Time. Thank you.
We went through some of those in our briefing, and the court can see that there's even more when the court looks at the exhibit.
Oh, God. I've been covering this,
I
so I
understand
missed
from the
it.
court's previous statement that the
I need
court
3 of me.
would accept a complete copy of something versus just pieces of it. Well, I could offer
Qualifies for
it.
the completion document. If it's necessary to explain the prior admitted stuff and it's close enough connection in time and in subject matter. And so there are some questions there. It's not just automatic.
We certainly would understand that
I'm
we'd
on for
have
the second
to
time.
present some information or
Not
cross-examine
late.
witnesses about that.
An additional
The
time.
additional bits of information that are contained in that record around that same time frame, though, provide a much better context when we're talking about other communications with social media, with saving pictures, creating new
Hidden gems.
contacts in
Thank you for
one's cell
that.
phone
I'll check it out and get
right before
recapped
the
on what I
texting
missed so
starts
far.
between
How
DM
can we
and
break
BF.
for lunch? They
And
just
then
got
subsequent
started
to
at
that,
2, right?
looking at pictures, editing pictures, calling family members. There's a much bigger picture than just this
He has,
tiny
Wendy.
little piece of texting between the two parties there at night. Further context about these messages the court should be aware that it's not just these messages. There's a lot more activity going on between these two people. And it's hard to tell what it is because there's telephone calls and those kinds of activities, as well as going down to one another's room, spending the time together, talking to each other, really take it out of an excited utterance.
Wendy, I wanted to let you know that, yes. So let me quickly recap while they're still talking here, what has happened so far. This started off this morning as a hearing about the use of the term touch DNA. So that was part of the issue, touch DNA. Over here on TikTok, please tap, 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 tap. We have 2,000 likes, but come on over here to the Big YT and let's watch this together, okay? There's a lot of trials going on right now. You're exactly right, Missouri. Thank you for joining us. So what the defense is saying is we don't want the video expert, the expert, to come forward and say that the car that allegedly belongs to Brian Kohberger was seen on every camera angle view, on every camera, and it was positively identified on every camera angle. That's not what's happening here. They want to exclude, they don't want to exclude the evidence. They just want to exclude the phrase on every single camera frame because it was only confirmed that they were in that one frame that belonged to his car, the 2025 Elantra. Not 2025, excuse me, 2015 Elantra. And remember, they went back and forth on those years. So that was the biggest argument for the day. So far up until this point, they've moved on to the 911 call. But they want to say that you can't say it's vehicle suspect number one because, in fact, it might not be for sure. So ultimately, what the judge decided on that is that the state should be making conclusions. The jury should be making conclusions on their own and come to their own conclusion. What you can say is the same type of vehicle is found in every single camera angle. You can't say Brian Kohberger's car is found in every single camera angle. So they're talking about phrases, DNA, touch DNA, what can be allowed, what can't be allowed. They don't want the 911 call entered in as a excited utterance. That's a specific term, okay? Excited utterance. They're saying because at the time the 911 call was made, the survivors had time to gather themselves, think about it, collect themselves, and talk amongst each other before the 911 call was made. So it wasn't an utterance, exciting utterance or the phrase. And that could be weighed significantly on what part the 911 call is going to make.
For each other's testimony or to bring in somebody else's statements through another person. So I think that it's important when the court analyzes if this is really an excited utterance to look at what's being said, as well as to understand the context right before and the context right after, not the next morning, the ones continuous, but right after.
Well, there are several things that I have to look at. One is, first of all, is it hearsay? Is it an assertion? Right? So,
Hearsay or assertion.
is it offered for the truth of the matter asserted? We get to those two things. Then we look at, is there an exception? For each of those two things, it generally means it's an out-of-court statement, then it's, unless otherwise definitionally excluded, hearsay. Unless there's an exception, then the exception being the excited utterance. And then we look at the surrounding events. Is it common or current present sense impression? Look at the surrounding events, what's said. Much of it is not assertions necessarily, or I would imagine some of it not offered for the truth, but simply to establish a timeline. And so I'll look at all of those things, but I don't think I can just look at the whole thing in whole and say, well, because they later on were doing things that,
I know,
19,
Holly. I've
20-year-olds
ordered an
do with
Ethernet
their
cable.
phone, doesn't mean that what
It'll
happened
be
earlier
here
wasn't
this
excited
evening.
utterance.
It won't, to make it unslow.
I understand. Our position is that those things that happen immediately thereafter impact the nature of those text messages that occurred between the
Hi,
two.
Mandy. If you are joining me over here on TikTok, we are live over on the Big YT.
Next
Come over to YouTube
item is
and let's watch this trial together. Pre-trial.
the demonstrative evidence.
can't believe he's sitting right there, Brian Kohberger like.
Thank you, Your Honor. In our motion regarding demonstrative evidence, we were talking specifically about, for
This
lack of
is
a
the
better
state.
phrase, a dollhouse, a not to scale construction, a 3D model of the residence itself. And as the court can see from the
Yeah.
materials that have been submitted, the configuration of this house is unusual at best. Certainly we can use diagrams and floor plans, which we did at the grand jury. But it struck us as we were looking at this case that it would be particularly helpful for the trial jury to actually be able to see in a 3D sense how everything's laid out. What is on each
Awesome,
floor,
John.
where the bedrooms are, how the first
Well, for
floors.
it to be demonstrative evidence, what's important is whether it explains the testimony of somebody on the stand and helps the jury understand it in relation to the testimony. And the concept of a demonstrative exhibit is that it's actually part of their testimony.
Yes, Your Honor, that's exactly what I was getting at. What we contemplate is the witnesses being able to use this demonstrative evidence to demonstrate where they were, where the rooms of their roommates were, where the entries to the residence were, what they observed,
Number our printers,
and
the
where
3D
everything's
model.
located. So it's not intended as a standalone exhibit that has significance. It's only a tool for the witnesses, not just the roommates, but the responding officers, the officers who investigated the crime scene, to point out to the jury where in this 3-story structure certain things were that they observed. And so that is our intent on this. We initially contemplated offering a 2-scale model. And the defense, I think rightfully so, said, okay, well, give us the background information and data that would be relied on. And we requested that, and for whatever reasons, we didn't get it quickly. But as we revisited it, we realized that to scale maybe is not what we want. We just want a demonstrative exhibit that witnesses can use, much the same as a sketch, or if they would take a flip pad and try to draw things to help illustrate their testimony to the jury. So that's where we ended up here. We look at the balancing test under 403 as far as relevance. We believe this will be helpful to witnesses in explaining to the jury and to the jury in understanding witnesses' testimony. As far as prejudicial effect, the state doesn't perceive any significant prejudicial effect. Now, I realize that the expert witness for the defendant talks about jurors misinterpreting angles of view and stuff. Well, that would be true if we were dealing with a 2-scale exhibit, and the defense is welcome to offer their 3D imaging or whatever it is that they want, if they want to have a 2-scale presentation. That's not our intent, though. Our intent is just simply to have this as a tool to help witnesses explain their testimony and help the jury understand.
And I think you understand this, but so that, it's clear. If it allowed as a demonstrative exhibit, it's not an exhibit in the sense that it goes to the jury. When they deliberate, it will not go back with them.
Yes, we completely understand that. We intend this to be something in the courtroom that is physical, that the jury can look at and the witness can look at and point to things so the jurors have the most complete understanding of what their testimony is.
I haven't seen it, so I don't know how visible it will be to, you've seen now where we're going to be, how visible it's going to be to the jury.
Thank you.
From where it would be presented. So I guess
We have
if I allow,
61
we'll
souls over
cross that
here.
bridge.
And that's
28
understood.
souls in
The
the
last
box.
communication we had earlier this week, Your Honor, from the folks at the FBI is that it might be finished within the next 10 days. I'll be candid. I had proposed to the FBI, let us get this in front of the court and get a preliminary ruling from the court before you spend the effort to construct it, but they went ahead and started anyway. So that's neither here nor there. It is intended, as you can see from State's Exhibit 1 or S1 with the dimensions in there. It's a fairly significant size, 35 by 48 by 52 inches. So the idea of making it big enough so the jurors can see it's out in the floor in the well, and they can actually see how things are constructed and arranged. It can take apart floor by floor so they can see each floor individually and then how they are stacked back together. So that's the purpose, to assist witnesses in explaining their testimony and assist jurors in understanding the testimony.
I get what he's saying. Oh, here we go.
Your Honor,
Here
we
comes the defense.
request that you exclude the state from using this dollhouse model,
Dollhouse.
as is everything we're talking about
mean?
here today. We're talking about Mr. Kohberger's constitutional rights, and we're talking about the rules of evidence. In this case, though, Your Honor, this goes beyond that. This is something that came up in 2023, the fall of 2023. We were disclosed that a group was going to the house before it was torn down to construct a model. We promptly asked in discovery to receive information about this model so that we could start to understand it, so that we could work with our expert with it. And it wasn't until 2025 that we get more information about this. I don't think that calling it a demonstrative exhibit excuses what the state has done here. The state said they didn't have any of the materials. They didn't come forth with them. Their date to be done with discovery came and went. Their date for their expert disclosures in December
that
came
part.
and went.
Demonstrative exhibits in trials are typically not brought to light in terms of being shown until oftentimes during trial itself. I mean, it's no different in some senses, as I'm hearing the argument, of sketching on a diagram on a pad.
It's completely different than sketching a diagram on the pad, Your Honor. This, if somebody's drawing something in
How?
open court, I can see them. Mr. Kohberger's confrontation rights about how that's drawn exist right then and there if they're drawing something on the board. This is an exhibit that's constructed outside. It's done in preparation for court. There were experts that took the 3D imaging to make this. There were photographs that were taken to make this. There's a process to construct this and to take it from to scale, which might have made some sense because things would be there where they're supposed to be. And by things, I mean walls, I mean doorways, I mean angles of hallways, I mean lines of sight. Those things would be there where they were supposed to be if we were doing this to scale. But to not do that and call it a demonstrative exhibit so they don't have to tell us about it
Sweatshirt on the front
is
row,
really
picture
misleading
of
to
a
the
male
jury.
yelling.
And there's a lot of danger for the jury to be completely confused by that. I don't think this change excuses what the state did to sit on this information and wait until the last minute when we don't have any ability to investigate it or to look at it.
You had access to the house, right?
No. What, to the old house? Yes, but not to what they're doing now.
But you had the ability to create your own models, to do your own measurements, to come to an understanding of the layout.
True, I agree with the judge. on this one.
Absolutely,
You
we
had
did.
time.
What we don't have the ability to do now is to test the state's model before it gets in front of a jury, before different witnesses use the state's model to say, this is where I was and this is what I could see. If a doorway's just off, the line of sight is just off. That can be completely misleading to the jury. This is an unfair surprise to Mr. Kohberger.
Me too, Hannah.
To
Very
have this
positive.
come in and have the jury look at this, it's not a PowerPoint. It's not a drawing on the board. This is going to be this big 3D model that's going to be pushed around the courtroom. It's going to draw the jurors' attention. They're going to put a lot of emphasis on it. A demonstrative exhibit that may or may not be accurate, that may have the walls and the lines in the right place or the wrong place, that won't have depictions of furniture or the
What do you
way the
think about
house
the house
really
argument?
existed that night. And the
What do you
jury
guys think?
placed great weight on that. And it might not be actual. It could skew the testimony. It could skew the truth. And that's really important in this case.
Where cross-examination comes in.
Your Honor, how can I cross-examine a 3D model that's constructed outside of a way I know
God,
anything
he's
about?
not messing
You
with
have
her.
access to the
Yeah.
house and you know what the house looked like and you have photographs.
I do have those things, but if there's
So
a slight
that's what
shift
cross-examination is for.
in this 3D model, it's going to be more difficult to depict that. And that's a lot of runs around to try to get our expert to take a look
They
at
could
this, to
just
try to
go
get our
there.
expert to pull the 3D picture that would show that this model's wrong, and to try to get the jury to want to listen to all of that, when the best and easiest thing for the court to do is just exclude it. This is not a model that will do anything but cause the jury to speculate. It could easily produce testimony that's not true. The jury might be relying on things, and likely will be relying on things that are not true. When you look at the case law
playing,
that talks about demonstrative exhibits,
They're not taking,
you're looking at things like PowerPoints. You're looking at, that's in the Weigel case, whether or not the demonstrative exhibit should go back to the jury.
they're not taking it literal line by line. They're just wanting to show and reference where people were. Their own testimony of whether they were in the line, in the side of a door or not.
Is the state. I've been in the house, so is the state. There's 3D imaging that was taken by the state and by the
I agree,
defense,
Dion.
with all of the thousands of photographs and all of the people that have been through the house.
Right, Wendy.
There's no reason to take a chance on this exhibit that will be speculative and will confuse the jury. To allow this is allowing the state to ignore the discovery process. They're just slapping a new label on this model and saying it's not to scale, so we don't have to disclose anything to
That
you.
woman,
To allow them to rename this is a violation of Mr. Kohberger's constitutional rights to due process and a fair trial. This should absolutely not be allowed. Mr. Kohberger we have done everything we can to be apprised of what the state's going to do. And at the last minute to pull this out after we've
Right,
asked in
Dee.
discovery for this, and to label
me
it
too, me too,
demonstrative
Gail.
exhibit, Your Honor, that just can't happen if Mr. Kohberger is to have a fair trial and if his due process rights are to be adhered to. We strongly object and ask the court to order this excluded.
Or in I don't know if it's LiDAR or what they use, the 3D information.
I'm sorry, Your Honor.
You have the laser information,
As of March 4th or 5th, I think that we did receive that. We sent that to our expert. He wrote a declaration in support of our objection to this, to let you know how long it would take him to do the work necessary to even measure this, and then he'd need an on-site visit for this. And if the court allows
too,
it,
Dee.
that's what we have to do. But the court should be well aware that when the state does these kinds of things, these things mean taking their time and throwing things out long after deadlines come. There's a ripple effect that happens.
Brian Kohberger,
We have to
Sophie.
work with our expert. The expert has to carve out time in his schedule. We have to take time to understand what's happened and figure out how to respond to it. We are very close to trial, and those deadlines are important for a reason. All of the stacking up of things like this at the last minute, outside of the deadline set by the court and outside of the rules, further prejudice Mr. Kohberger and his ability to have effective assistance of counsel at trial.
They did not meet the deadline. That is true.
Your Honor, what Ms. Taylor is talking about might be true and applicable if we were offering a scale model. We made the decision not to. She complains about the timing of the underlying FBI data. Well, that request from her for that information related to a proposal for a scale model. And we provided it anyway because she had requested. In our view, it has no bearing on whether the demonstrative exhibit is acceptable and appropriate. The allegations that we've tried to sit on this and bury this, that's just silly. That's not
It
what
is,
happened.
sweetie.
We provided the information we received. As soon as we received it, it was processed. I don't think that the defendant can point to anything to say otherwise than that. It's just simply a demonstrative 3D model to help the witnesses explain their testimony and help the jurors to understand the testimony. That's all we're asking for.
thank you.
Okay. What do you think it's going to decide?
I will give you a written decision on this soon, shortly, but there is a significant distinction between demonstrative trial exhibits or trial models, charts, things of that nature, and attempts to use things for evidentiary value in and of themselves. And the more complex, it's not particularly different than a drawing by a witness or something of that. It's not uncommon to get these very close to trial. Defense counsel has had access to the house, could have done its own diagramming if it had wanted to. It has now the information on the, I'm just going to call it the laser or LiDAR and modeling measurements, whatever that was done by the
Hi,
FBI.
Southern Belle.
It's April. Trial is
Good to see
starts in
you.
August. I think there's plenty of time for the defense to respond to an item that is not actual evidence. It is simply part of testimony that will be forthcoming at trial. And will not go to the jury.
Right,
Jury
Christy.
will not have it in its presence when it deliberates.
Good morning, Henry.
I don't
Or good evening. I'm stuck in the morning time, Henry.
see, frankly, the concern with respect to the use of a model in a
You
case
do,
like
sweetie?
this. So I'm going to allow it.
I'm not sure.
The state will make it available to the defense
He's going to allow it.
prior to the pretrial conference and sooner if it doesn't sound like it's complete yet, but as soon as it's done and certainly as quickly as possible. And like I say, it's not going to be allowed for evidentiary value. It will be a part of the testimony. Whoever testifies is going to have to testify that it helps explain their testimony and that it's consistent with their observations. That's subject to cross-examination by
I
counsel.
think he's going
If there
to
are
agree to,
problems with the
to admit
model
the
in terms of
house.
view lines and things of that nature that they were able to put together through their own visits, through their own studies, through their own opportunities, including through their experts if they want to. So.
Okay. I like this judge so far. They're sitting there like,
All right. Next, I have self-authentication of records and reliance on 803. I'm not sure we're ready to argue this because I don't think the state has complied with the obligations in order to rely on the self-authentication issue if they haven't provided the specific documents and certificates that they're intending to rely upon in advance of the motion at this point. So I'm not sure that this isn't premature.
Yeah,
He
Your Honor,
really
We
is.
agree. That's probably an accurate statement. And a better time will be after the exhibit witness list is due. And then the parties have to get together and determine what exhibits we have objections to, and then we can address this issue.
Part of my scheduling order is a
That's
meet
right,
and
Steve.
confer over the exhibit lists.
I wish
to,
they hadn't have.
Determine whether there's a good faith basis for an authenticity objection or not. And certainly the rules on self-authentication are crystal clear as to what is allowed. And so if it meets those, then I imagine we won't have a problem. Add anything, Counsel?
No, Your Honor, I won't right now.
Okay.
All right, let's talk about alibis.
Oh, shoot. Alibis.
This is the state's motion in limine.
Somebody, don't let me miss Lori Vallow, Daybell's trials. Don't let me miss it. If you start, somebody let me know right away.
Thank you, Your Honor. Excuse me.
I'm sorry, how butterfly?
First off, I want just for the record to make a record of the corrections to the typos that I missed in our initial filing. I emailed Your Honor staff attorney and counsel over the weekend. There were dates that were wrong. Page 1, item number 2 of our motion. It should be July 27th instead of July 22nd on that particular court filing from 2023. We overlooked, and I apologize, the defendant's July 24th, 2022 initial alibi response, which, as the court can see, essentially wasn't a response at all, other than we'll come up with an alibi at some point. And then page 2, item number 7, it should be February 29th instead of February 23rd
Welcome back,
for the
Jim.
date. And I apologize to the court again for those.
Welcome in, better lover.
Certainly entirely my fault. This issue has been argued back and forth in court since 2023, as the court can tell from the numerous filings that have gone back and forth up in Latah County that brings us to today. The state filed in accordance with the applicable rule and statute 19-519 and Court Rule 12.1, a discovery request with an alibi demand that requires the defendant to specify the place or places that he claims to have been at the time of the alleged offense, and then identify witnesses who the
Stargazing.
defendant intends to
So
rely
it's
on
about
to
to come up.
establish that alibi. The state's position is that to this date, the defendant has yet to do that. The best that we have is the defendant was out driving around. Well, we knew the defendant was out driving around. We have other evidence that show the defendant was out driving around. His phone was turned off, so we can't trace his exact location at the time of the offenses, but it overlaps and coincides with the time of the murders.
Watch Kohberger's face as he's talking about this. Watch his facial expressions.
The can's been kicked down the road several times on this, and it's nobody's fault. Judge afforded the defendant multiple opportunities to provide a compliant alibi response. That never occurred. The defendant's response from earlier this year doesn't have anything new or different. Talks about partial corroboration of a partial alibi, which frankly, the statute doesn't talk about
Holly.
partial anything, nor can we find that in the case law. The defendant acknowledges that their cell phone expert, Mr. Ray, can't account for the time of the homicides itself. Of course, we know that because the defendant's phone was turned off. So the only person who can testify to an alibi, if there is an alibi, is the defendant himself. If he elects to testify, that's fine. And the state's position is that he's allowed to testify, but under the statute and the rule for alibi notifications, there should be an order from the court prohibiting evidence from any other witnesses as to the defendant's location at the time of these offenses. The defendant retains his right to testify to that if he elects to do that. But nobody else should be asked to testify about specific places where the defendant has been, because we can't respond to that at this point. And to our knowledge, there's nobody else who can say the defendant was at a specific other place.
What about their cell phone expert? As I understand it, will testify as to where he was or wasn't.
I don't believe that that's what his expert can say. The best their expert can say is that before the defendant's phone was turned off, the defendant's phone was south and potentially west of Pullman. But that was a significant time or a notable time before the homicides themselves occurred here in Moscow. There's nothing in the cell phone data that shows where the defendant was at the time of the homicides.
You don't disagree about the right to put on that evidence?
No, that's fine. I mean, that's an issue, the battle between the cell
Thank you,
phone
Moses.
experts
Thank
on
you.
the activity of the defendant's cell phone and what direction it was, but that doesn't apply to the time when the homicides occurred.
You're just looking to ensure that there's no witness who's going to appear who says, oh yeah, he was at my house at 406.
Yes, sir. Thank you.
Here we go. She sounds like the teacher from
Mr.
Charlie
Kohberger
Brown.
has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And who can testify to that?
I'm going to get to that. We provided Mr. Ray as a partial corroboration of Mr. Kohberger's alibi in an abundance of caution. The thing I didn't want was to be here with Mr. Thompson saying they should have told us they had a partial corroboration. Now they can't use it. So that's why we disclosed Mr. Ray as early as we possibly could. Mr. Ray took the stand in a motion hearing last May, I believe, and the state chose not to cross-examine him. I disagree that Mr. Judge gave us repeated opportunities to produce more. There was a mix-up about what an order meant when speedy trial was waived and the trial was reset and all of the deadlines were extended. That was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more. But I will say this. This has been brought up repeatedly by Mr. Thompson. His pleadings with the court, his briefing, have a lot of reference to Mr. Kohberger having the ability to testify. In the few minutes he spoke just now, I counted 5 times he made reference to that. Our view is that's getting dangerously close to commenting on his right to remain silent. And I would cite the court, the closest case we could find was State versus Haggard. That's at 94 Idaho 249.
I think the issue is who's going to say he was out driving around looking at the stars?
Right. You're getting
Well, Your
off
Honor,
track
I think
here,
that's going to be a
lady.
trial issue. And I think that if that's commented on trial, that's a comment on his right to remain silent.
The question is whether they can comment on it. The question is whether you have a witness who's going to testify to that he was at a particular place between the hours of 2:57 and whenever his phone came back on and 4, whatever it was.
448.
4:48. If so, you have an obligation to produce that. If not, and your testimony, your presentation is that this is what was going on, you have to have somebody that's going to put that into evidence. You can't testify to that.
I'm certainly not planning to testify to that.
I
I'm
love this, Judge.
responding to requests for alibi. And a lot of times in cases, there is not going to be a response because a person's alone. The court's aware of that. But when you have what I considered a partial corroboration, that had to be put out there so that I could make sure I could call Mr. Ray to the stand.
I don't think they're
Right, Valerie.
as far as I can tell.
That's what I heard them say today as well. I'm explaining why we put that out there. I would say that the state is continually asking a question that is a problem that hasn't arisen at this time yet. The only fear that I have because of their repeated questions is that there is something somewhere in the 68 terabytes of discovery that I haven't come across yet. If that's the case, I'd ask the court, if they know of it, I'd ask the court to order them to tell me about that. I can let the court know I haven't read every document in 68 terabytes. I haven't watched every minute of video in 68
should have.
terabytes of discovery.
You've had years to do
We have
it.
answered the question.
I know, go,
Now,
go, that's
we've
what I'm
answered
thinking
the
too.
question before, and this continues to come up. I would point out, though, that Idaho
Right,
Code 19-513 subsection 3 that says if we learn of an additional witness that was not previously known, we can disclose that and the state can challenge that at a later time. I don't have that person now, but if I continue to review discovery that the state produced to me and I find something, then I'll bring it up. But I don't have that now. What I have is partial corroboration, and that's what I intend to produce. I also intend to cross-examine the state's expert about that if he's allowed to testify.
The end.
Your Honor, the notion of partial corroboration of the alibi is concerning because that kind of begs the question between complying with the alibi disclosure statute or not. And
Well,
it's that,
why shouldn't we just look at this in terms of the defendant's version is that Mr. Ray, in his expert work, is going to testify the defendant was at a certain place at a certain time, which is up to 2:50, whatever it was. As of this point, they have provided no other alibi witness,
yes, sir.
or the alibi instruction likely is not going to be given.
Yes, sir.
If they come across evidence that supports an alibi, is their obligation to immediately make you and the court aware of it? And then we'll deal with the issue of whether it is
Right.
the timeliness of it and how we deal with it.
Thank you, Your Honor. The court articulated it much better than I could. That's exactly what we were looking for. Thank you.
Yes.
Right.
She wasted time and solved nothing ever. If you have an alibi witness, you'll present it, even if it's not here yet. She was trying to see the future and argue over something that may or may not happen in the future. No. Taxpayer dollars hard at work, folks. Yeah, he's pretty awesome. I like him.
Right. Let's talk about the AT&T stuff.
Thank you, Judge. This should be fairly simple. The state's seeking an order prohibiting the defense from continuing to allege that the state received timing advance records from AT&T for Mr. Kohberger's
When you
phone.
say continuing to allege, I'm assuming you mean in front of a jury.
Yes, what we don't want, throughout the entirety of this case, they've alleged that. We're seeking to prohibit them from making that same allegation in front of a jury because it's false. Timing advance records, really timing is what's at issue. And in 2022, the days that we're concerned about are 7 days. The event that we wanted records for was obviously November 13th. So in 2022, we had 7 days from November 13th to get AT&T timing advance records for anyone's phone. We did do search warrants for other people's phones. We did a tower dump and we did a search warrant for 3 individuals. Those were all done on November 16th within that 7-day period. So the state did receive some timing advance records. However, by the time that Mr. Kohberger was identified in December 19th, and by the time we applied for a search warrant for his AT&T records, we were outside of that 7-day window. So there were no timing advance records to be received, and we did not receive any. The state has submitted an affidavit from Stephen Gordon, the AT&T Director of Compliance, essentially stating that we sought timing advance records, but they were not included because more than 7 days elapsed since November 13th, 2022, and the date of the search warrant, December 23rd, 2022. And the state just submits these affidavits should be dispositive of this issue.
The defense filed a document yesterday. I don't have all the attachments, but it talks about a timing advance that was produced by AT&T in last April, I think.
Yes, so for that, it's still in reference to these search warrants that were initially asked for in November 16th of 2022. We did a part 1, and then later we did a part 2. But because we put in that request within the first 3 days, obviously a preservation request was also put in. So those records were obtained. So again, we're
So
talking.
you're indicating that there were records obtained as part of your prior notification of need for AT&T to preserve those records.
I have nothing further. Thank you.
Well, if it didn't happen, it didn't happen.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance
What
records.
evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor, specific,
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue and doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records, on December 23rd, there were 2 separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us.
Hey,
What
Angie.
I've learned in working with Mr. Ray
Right.
is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for this time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not
Yes.
produce
I don't
those
think he likes her very much.
records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way that
It's the other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once and they said, oh, no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit. It's a glaring omission.
Thank you, Kelsey.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
For the 7 days that he's back home,
maybe.
I'll ask the state about those. If they receive those, I'm not sure their search warrant covered that time frame, but
Send me a message.
Your Honor, I would say that it
TikTok
did,
maybe.
and I would say their first search warrant was just a 48-hour period. It asked for timing advance records, but then the second warrant,
you would
which
agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Kohberger was identified.
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that, and here's why. Here's why. The things
Thank
that I've
you.
learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
If they don't
The
have
evidence
it, they
and general
don't have
practice
it.
That I learned from people that I've
You're
worked
giving
with.
me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
Okay. But you've made some serious accusations against the state of hiding evidence. And yet you've provided no factual basis, zero, that that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's
FBI?
timing advance.
Because they were asked within 7 days of the date that they sought it. It was the tower dump from the night of the murder asked within the 7 days.
I understand that.
Okay.
Don't
So where's
understand
the
that.
evidence that Mr. Kohberger's timing advance records from AT&T
You don't
were available
understand
to
that.
anybody in December? without a prior request that they save those.
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't because they didn't know who he was.
Right.
You're correct. They didn't know who he was until I think about December 19th.
Correct.
Past the
Their
7
warrant
days.
for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's, even if they were just the 7 days back, I haven't seen any of
What you're
them.
talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood
about-
how timing
Yes, Your
advance
Honor,
worked,
and sit
became
down.
very important.
But she's not going to win.
We've heard different things now than I've heard at different times in the past about
Thank
this,
you, Kelsey.
particularly about the 7 days. That's newer information to me now. But the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December,
No, Your Honor, because the 7 days is something that's newer and has been brought to my
our
attention more
motion to
recently.
compel related to timing advance records for November 13.
Our discovery requests were for all of Mr. Kohberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request
She
now
makes
that
me-
says 7
She
days.
makes me want
And I
to
have the
take a
affidavit
shot
now that says 7 days.
of tequila.
Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that and you,
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's
Thank you,
accusations
Nosy.
without addressing the 7 days that he had that information when he submitted his affidavit.
he is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this. And you haven't
Oh,
done that. It's
Hand it
affidavit
over.
is quite expensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days. And he supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time, for all I know. He didn't name names, he didn't identify it, he didn't put it into any context. The state had indicated and that provided AT&T's sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that that was available to them by the time Mr. Kohberger was on the radar as it relates to November 13.
Oh my
And I'm not
God.
seeing that as the problem.
What
first
if Lauren
question to
Daybell showed up to
Special
represent
Agent
Frank
Balance would be the
Kohberger?
person who would have gotten these through a different channel through the FBI, would have been, did you get them? Because I've heard different things along the case, asking him the question is really what I wanted to be able to do. And that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury
Thank you.
at the time of trial.
That will satisfy me. Thank you.
No, it won't. You're just giving up. You're be glad I didn't turn out as a judge.
And I'm not upset, but I just for Mr. Ray's information, because he wasn't here the first day I started this trial with you folks. I said,
Thank
I don't want
you.
theatrics. I don't want
It's by
accusations
Adriana Nicole. It's in my
with
TikTok
evidence
shop.
about
Gold
supposed
palette.
bad conduct with the parties. You're all professionals. I respect you all. And the accusations he made in there are very concerning. The kinds of accusations, if true, that would get people disbarred.
Oh, that's right.
And so without any evidence and apparently sidestepping the clear
Mhm.
explanation, he makes those. And so that doesn't make me happy.
Mm. Right.
And to address the
Serious
court's concerns
accusations.
with what's raised, I think the only issue out there, I have the 2 search warrants. The state asked for the AT&T timing advance records in our search warrants. The state wanted that information from Mr. Kohberger. We did not receive it. I did not receive those records from AT&T. I do not have them. Thank you, Your Honor.
All right. There's not been a showing that those records were available. And I think it would be unfairly prejudicial.
It is, Miss Chris.
To try
I'm
to
live on
impeach the
YouTube.
testimony of the agent that somehow he hid or didn't provide or didn't use records that he didn't have available to him. So
You can
absent
read
some
them.
factual showing that he had them available, I'm not going to allow questions about that. And I'm not going to allow testimony about that.
I'm sure
now,
it is.
If you
I'm
want
getting an
to
Ethernet cord.
him before he testifies in front of the jury, I'll allow that. And if you
May
show a
5th,
factual basis for it, I'll allow it, but you haven't at this point.
I appreciate the opportunity to ask the question outside the presence of the jury. Thank you.
Thank you. All right. The vague and undisclosed expert testimony, I think in part touches on this, but not entirely. So I'll let you talk about the other entirely part.
Yes, thank you, Judge. Then you'll get a break from me in a few minutes, I think.
I enjoy dialoguing with you, counsel. I appreciate it.
Well, good. I think we're going to have some time together over the next 6 months or so. Your Honor, this motion came after our hearing in January, and we're asking the court to limit
Me too,
what the
sweet.
state can produce with their experts here.
Me too, Colin.
I do have copies for the court, extra copies for the court. We had a specific request at the end of our motion. We called it Exhibit 1, and it went through all of the state's experts and basically described what we think the court should do with the state's experts. And so I wanted to provide that to the
So
court.
I did see that.
Okay, good. Thank you. Let me get to my same page. I want to start though today with my presentation and my request with a little bit of history with this case. And as the other motions are, this motion, our motion for the court to exclude all of the state's experts as outlined in our exhibit is based in Mr. Kohberger's rights to a fair trial, effective assistance of counsel, due process, and guaranteed by discovery rules and rules of evidence and the court's own scheduling order.
It's rooted in Rule 16, which is kind of where the court looks at these issues.
Rule 16 it is, yes, Your Honor. This started with discovery requests very early on where we asked for expert information from the state. I'll skip forward to the court's scheduling order, which was very clear about what should happen and that we needed to have our expert disclosures in at a certain time. The state's date was December the 18th, and shortly after we received the state's expert disclosures, we filed a motion to compel. We wanted the rest of their disclosures. We had a dialogue in January about that, and the court asked me, why are you doing this? I'm going to make them abide by the rules, by the discovery rules. I really thought when we filed that motion, the state would say, oh, okay.
All right, I'm going to take like a 10-minute break, clear my mind for Lori Vallow Daybell. I'm going to start the trial here in a few minutes. When it starts, I've got to go cook dinner, so I may not be face on, but I'll be in the comments talking to you as we gasp at Lori Vallow Daybell's trial of her representing herself. And then once I get dinner done and the whatnots, I'll come back in here and sit down with you guys and we'll watch the madness together, okay? Make sure you're following me on the Big YT if you are not. That way, when the Lori Vallow Daybell madness starts here in a few minutes, we can watch it together on YouTube. I'll be back here in just a few minutes. Let's take a short break. Thank you guys. Thank you, Gail. I'll see you over on the Big YT.